My name is Bob Brogan. I'm a certified elder law attorney from New Jersey. On behalf of the National Academy of Elder Law Attorneys, Stetson Law School, and the MS Society, I thank you for joining us in this presentation. It's a result of an alliance between NAELA, MS Society of America, and Stetson Law School, who are producing these videos. We thank them for their participation. Today, I will be giving you some information that's particularly helpful in addressing the long-term care options for younger people afflicted with MS. We find that as people are diagnosed, particularly in their earlier years, they find themselves facing various medical concerns and various legal concerns that other folks may not normally be addressing until many years later in life. As a result, we've put together some information. In the PowerPoints, we're trying to give you some background to educate you and give you things that you can then take and sit down with someone knowledgeable in this area so that you can get the right advice and get the right guidance to make good decisions from a legal perspective that can help complement the decisions that you want to follow through on from a medical perspective. With that in mind, I wanted to start by some advice that a family member of mine who has been dealing with MS for over 30 years gave to me when I advised her that I was going to be giving this presentation. The first thing that she said was most helpful in her situation was to find a good doctor and develop and nurture with that doctor a close relationship with them. In particular, the other thing she suggested was to appreciate that everybody's path with this diagnosis is uniquely their own. She put it this way: don't read too much. And while I am a ferocious observer of knowledge and try very hard to read everything I possibly can, what she really meant by that, and what I'll pass on to you, is to live your life, to understand that this diagnosis is going to be something that's specific to your situation, and how you progress with it and the steps that you're going to take in addressing it both legally and medically are your own steps. Not everybody's situation is the same, and therefore address the information that you need and make it apply to you and your situation. One of the questions that we're often asked is how to provide the funding for care. In particular, we're going to talk about using Medicare, using Medicaid, the limitations of private insurance in ways to pay for care. As you may have already discovered, or you will soon discover, there is a dearth of information out there in terms of what medical services you're going to be able to qualify for. There are limitations under private insurance, there are limitations under Medicare, and there are limitations under Medicaid. And we're going to try to spend some time working through those for you now. Let's start by just breaking down the differences between Medicare and Medicaid. I find that many people just do not understand how one relates to the other or is the same or different. The way I normally describe it is that Medicare is a health insurance program. Medicaid is a health care program for people who are impoverished. So that's the first thing to think about, is that with Medicare, if you've been working, you've been paying into the Social Security system. For most people, they recognize it as the FICA portion of their pay stubs. And so it's federally administered through the Social Security Administration. It's an entitlement that's based on eligibility. That eligibility criteria can be one of two things. It can be either age-based, meaning if you're over 65, you're eligible for Social Security Medicare, or it can be based on disability. And we'll talk about that criteria in a little bit. There are different services that are provided. You can get hospitalization coverage under Part A. You can get up to 100 days of rehabilitation coverage. If you've had 3 full days of admission into a hospital, then you may be eligible for rehabilitation services and therapy for up to 100 days. There are also prescription drug benefits under Part D that are specific to Medicare, but Medicare has some limitations as well. You're going to have premiums, you're going to have co-pays for the supplemental programs that are picking up the differences between what Medicare leaves uncovered as a co-pay for you, the beneficiary, and what you want to have your secondary insurance cover. One aspect of Medicare, which is very different than Medicaid, is there is no estate recovery. That is to say, because you've been paying into the program for all those years, when you get the services provided by Medicare, there's no ongoing lien being attached to your assets, and there's no ongoing bill that's being determined that you would later have to pay back or that your state has to pay back. You are getting explanations of those benefits letters from the Social Security Administration, but that's really to advise you what is your portion and what is the portion that the Social Security Administration is going to pay. Let's compare that with Medicaid, for example. In Medicaid, it is funded by both the federal government and the state government, but it is administered at the state level. In most states, you actually apply at the county level. There is both a financial and a disability criteria, and we refer to this as a means-tested eligibility. That is to say that you have to be below certain criteria financially before you're going to be approved for Medicaid. And we're going to talk in detail about that. To give you a basic idea, you have to have assets as an individual that are below $2,000, and your monthly income may not be beyond approximately $2,100 of gross income per month. There are benefits to Medicaid that are different than Medicare in terms of the services provided. You may be eligible for skilled nursing care, what we would normally call a nursing home in a skilled nursing facility. There's intermediate nursing care that Medicaid will pay for, and there are long-term care and other prescription services that Medicaid will pay for. Medicaid will pick up, for example, the copay that Medicare does not provide if you're eligible under both programs. We call those people dual eligibles. A key difference in Medicaid compared to Medicare is that Medicaid has a reimbursement requirement. It has a state recovery. And what that means is that you may have assets that were deemed unavailable during your lifetime, but if you still have an ownership interest in those assets on your death, the state can receive a repayment of the services that were provided to you from your estate. And that's a key distinction between Medicaid and Medicare. There's also spend down requirements. If you have in excess of the $2,000, or if you're a married couple and you have assets that are above a certain amount, there's portions of the assets that are allowed to be set aside for the spouse who stays home. That's called the Community Spouse Resource Allowance. And there's portions of the assets that have to get spent down to the $2,000 for the person in the couple who's applying for Medicaid. We use different tools and techniques to get people down to that criteria, spent down to that eligibility level. Sometimes if it's my own money, that involves the funding of a special needs trust. And other times, if I'm married, for example, there may be spousal planning involved in order to assure that our legacy is not only going to pay for health care. Let's look at, for starters, just the definition of disabled. And in particular, I want to stress the urgent need to file for your Social Security Medicare benefits in a timely manner if it turns out that your symptoms have progressed to a point that you fall under this definition. An applicant is disabled if they are unable to engage in any substantial gainful activity by reason of any medically determined physical or mental impairment, which can be expected to result in death, or which has lasted or can be expected to last for a continuous period of not less than 12 months. That convoluted definition basically stands for the idea that if you cannot engage in a substantial gainful employment, and you've satisfied that to the Social Security Administration's criteria, then if you have had enough work quarters applied into the Social Security system at the time of your application, you can qualify for Medicare. Why is that important? It's important because I find that for some of my clients who have developed MS and continue to work, they have trickled down the number of hours that they're working over a period of years. And they've reduced the hours, but if they wait too long to the point where they haven't worked in many, many years, and then apply for Social Security disability, because the Social Security Administration looks at the last 10 years of eligibility, the last 10 years of paying into the system, we call it, then you may be stuck and you may find yourself ineligible to apply for benefits that if you had taken action early enough in the process, you could have been getting a better coverage. You can get this coverage even before you turn 65, and that's a key distinction between the benefits that are available. If you qualify for Social Security disability, 24 months later, the Medicare coverage starts. And while there's no way to shorten that time period, and you may later want to apply for Medicaid to cover some of the services in that time period, if that's appropriate, you want to at least get that clock started so that you're getting closer to having those medical services available to you at the earliest possible phase. Our experience has been that there's inadequate funding for home care services under Medicaid. And as a result, we encourage people who are eligible, who have worked into the system, to apply for Medicare at the earliest possible point. Let's talk about some traditional problems that Medicare has presented. And I want to spend a little time discussing a case that has really been a monumental shift in the focus of how home care services in particular are going to be provided. Traditionally, people have been denied with MS for services like physical therapy, home health care services, the necessary and important services that often help us maintain independence in the community. Under Medicare, there had been traditionally a $1,900 annual cap on provided services, and in most private pay insurance, there are limitations on the number of therapy service units per year that you're entitled to. Therefore, even though the ACA may have an expanded eligibility and may not have pre-existing conditions associated with it, the private insurer that you had under your prior employer, for example, may not be sufficient to satisfy all the needs and services that you find yourself in need of. And even prior to ACA, those pre-existing conditions often excluded services that were necessary to somebody who already had developed MS and were symptomatic. Under federal law, the Social Security disability coverage was supposed to go beyond that. The coverage under Medicare was also, for rehab purposes, supposed to be to maintain a level of eligibility, to maintain a level of independence, to maintain a level of ability, if you will, such that if you didn't have those therapy services, if your level of ability went down, you should be eligible for that Medicare coverage service. This was a radical shift. This was about a year and a half ago. There was a settlement between the Center for Medicare Advocacy in DC and Connecticut with the federal government. And as a result, services now can be provided if they're medically necessary to maintain that function. And as a result, we get home health care services, outpatient therapy services, and these are in a less restrictive environment than the skilled nursing. And most of our clients really have no interest in transitioning to skilled nursing until it is an absolute necessity on many levels. By utilizing these Medicare services, you'll be able to maintain your independence in your home setting longer than if you didn't have that eligibility. Let's talk about the different places and services are provided. There's home living, supportive living, and facility living. The vast majority of my clients obviously prefer to get services at home. This is at your house, at your apartment, at your condominium. There's also services in supportive living. These would be more like group homes and personal care homes. Assisted livings are developing programs for people with MS, though traditionally they are more focused on folks who have memory problems. And as a result, the fit may not be quite right in assisted living. Finally, for those who are progressing with the disease so much that they cannot have certain activities of daily function, they're having gait issues, they're having other issues that require full 24-hour skilled nursing, then you have facility living. This is nursing homes. It also includes auxiliary hospitals. Those studies have shown right now there is a critical need to develop wings at these long-term care facilities, specifically for populations with unique specific needs, like folks with MS. And I think that's going to be something that's going to be developing over time. If it turns out that you do need to qualify for the highest level of services, and as a result, you're going to need to apply for Medicaid, there are different trusts that are at play, which you may need to understand in order to obtain Medicaid eligibility. Let's look at two of the main ones. The comparison that we usually make has to do with whose funds are being used to put money into the trust. We have first-party trusts, and these are created by the beneficiary's parent, godparent, grandparent, guardian, or by the court. Notice that it doesn't include me as one of the people that can make my own trust. This has to do with a mistake in federal law going back to 1993. In the federal law that created the eligibility for that kind of first-party trust, Congress forgot to include the beneficiary themselves as a person who can create the trust. NAELA has been advocating as a primary focus of their public policy for the last year the Special Needs Trust Fairness Act, which is designed to correct that mistake. So hopefully, within the next year or so, we will get that act passed and you yourself can create your own first-party trust. There is also before Congress the ABLE Act. We're now filming this in Florida, and Congressman Crenshaw from Florida has been a pioneer of that act for the last several years. And that is called the Achieving Better Life Experience Act, designed so that people can set aside a certain amount of funds and still qualify for Medicaid under specific criteria. What you may find is that you even if ABLE gets passed, you're still going to need a first-party trust and an ABLE Act account because of the limitations of the ABLE Act specific rules. Therefore, let's look at how they differ. In a first-party trust, the beneficiary must be under age 65. Again, that goes back to the 1993 law. There's additional requirements that are imposed from state to state because Medicaid, as you may recall, is funded by both the federal government and the state government in a partnership. Therefore, each of the 50 states may have different rules specific to how they interpret the first-party trusts in their state. The one thing that's uniform throughout all the states is the requirement of a payback provision. What this means is that if there are any funds left in the trust at the point that the person passes away, those assets need to be returned to the state, and that means every single state in which benefits were provided, to pay back the lien that's been accruing during my lifetime for the services that I was provided under the Medicaid rules. So that's a first-party trust. A different situation would be if you had a third-party trust. This is funds created by someone else on my behalf. For example, let's say I was a person in my 40s and diagnosed with MS. And let's say further that I knew I was going to need Medicaid in order to qualify for all the care. Good example would be is if I had not had a sufficient work history and I wasn't eligible for Medicare, then Medicaid would be the way I would be able to obtain insurance coverage. If that were the case, I may want to end up discussing with my parents, ensuring that I don't inherit anything from them. That to do so would ultimately take me off of Medicaid because I now have assets in excess of $2,000. That third-party trust can be a living trust or can be created by will. So the parent could create the trust as what we call an inter vivos trust, meaning during their own lifetime, or within their will, also referred to as a testamentary trust. And that trust could be set aside to provide for various services to supplement what Medicaid is already providing to me, but not be an asset that's an available resource, which would make me ineligible for Medicaid. So the key there is that it's funded by someone other than the Medicaid beneficiary. Another relevant distinction between the third-party trust and the first-party trust is that in a third-party trust, there is no requirement for a state recovery, nor is there any requirement for a payback provision. What that means essentially is that if a parent wants to set up a trust for an adult child, but has other children, the beneficiaries of that third-party trust can be the other children if there are any funds left in the trust on the beneficiary's passing. Compare that with the first-party trust, where the Medicaid services are going to be paid off in full before anybody else, as an heir at law, inherits the balance. And what we mean by that is that the balance in the trust can pass to other family. So that is a real distinction that you want to pay attention to. Another distinction has to do with how do we deal with assets between couples. In many states, you can provide under federal law a testamentary trust where one person provides for their spouse's fund to be created but not given to them directly. That trust could supplement the benefits that the spouse is receiving during his or her lifetime, and then pass on to the children as a third-party trust. In my own home state of New Jersey, we have a unique case that says that you cannot do that. So the point there is you really need to benefit from the knowledge of somebody specific to your state's laws. The distinction from one state to another state, particularly states that are so divergent as Florida and is from New Jersey, is going to dictate whether or not one approach is more appropriate for you as a family. These situations are not cookie-cutter situations. Instead, they are, as we said at the outset, unique to each individual family. What assets you have, what progression of the disease you have, at what point in your life you're being diagnosed, will all influence the best approach that you need to take legally. Certain things are almost a given. You want to ensure that you have a good power of attorney up to date. You want to ensure that you've taken care of your living will, sometimes referred to as a medical directive or a healthcare directive, or sometimes a general power of attorney for healthcare decision making. Make sure that you have proper HIPAA designations in a document so that your spouse or your other loved ones can speak with your doctors if you're not in a position to do so and get information. Think seriously about those people that you do want to have access to information or be there and help you. Ultimately, you want to ensure that you avoid guardianship if at all possible. Guardianship is if you become incapacitated and can't make decisions for your own benefit. If you can communicate, they'll follow your instructions. If you can't communicate, guardianship may be your only resort if you haven't taken the time to put the right plan and the right documents already in place. So we strongly encourage you to reach out to somebody. One way to determine who's good, I'll provide that here for you in this slide, which is you can look to see for people in your community who are members of NAELA. The last thing I wanted to point out was that these decisions overlap both medical, legal, and financial implications. The MS Society has produced what I would refer to as an excellent resource that I'm suggesting anybody who has developed this disease to take some time and read through the resource. I've given you the link here in the PowerPoint. Walk through it, and it has some great opportunities for you to write down information that's specifically yours and to determine from that information what are the things that you need to be thinking about. Take the time to work through that. Take the time to reach out to an attorney who's familiar with these situations and can help guide you on what may be the most appropriate legal approach so that you can get that part of it taken care of and spend more of your time focusing on how are you going to work through the various things that are affecting you medically because MS is now a part of your life. We hope this has been helpful, and I thank you for listening.